Hello, Poly 100. In the past few weeks, you've been learning a lot about federalism, about civil rights, and this week, the courts. Now, if you've been following the news, you may have heard a lot about the Supreme Court recently, from the death of Justice Ruth Bader Ginsburg and some of the politics around a pre-election confirmation of Judge Amy Coney Barrett and whether or not that'll happen before the election. But today, what we're going to do is focus on Obergefell v. Hodges, a very landmark case decided by the Supreme Court on June 26, 2015, that ruled that the fundamental right to marry is guaranteed to same-sex couples. All right, you see a lot of happy folks outside the Supreme Court on that day celebrating that ruling. But before we get into the facts of the case, let's first go over a few helpful terms. So plaintiff versus defendant. Plaintiff is somebody who is bringing a case against someone, and a defendant is the person or persons being sued. Writ of certiorari. There is a lot of debate about how to pronounce this Latin term. Even the justices themselves disagree on how it is said. A lot of people will just say writ of cert. But it is when the Supreme Court reviews a decision of the lower court. Now, there's also this thing called Rule of Four. When the Supreme Court receives applications to hear cases, they will have a rule of four. So if four justices decide that there is value in the issue, they will issue a writ of cert. And then also moot, another term that we'll be coming back to a little bit later on. Essentially, you cannot litigate a case if the issue is already resolved. And then the oral arguments, the audio is available actually for every oral argument. So if there's a Supreme Court case that you're incredibly interested in, you can look up and listen to it. This is a time for the attorneys to really lay out the legal reasons for the case and answer questions from the justices themselves. Now, you may say, why are we going to spend the next few minutes talking about marriage, of all things? So I'm going to ask you, who in our political system regulates marriage? It's the states. Congress wasn't given this power. So think to yourselves about some of the different states you've heard of and their laws about marriage. And that'll really set the tone for the facts of this case. So this case, Obergefell v. Hodges, is actually a consolidation of four relevant cases from Michigan, Ohio, Kentucky, and Tennessee. Same-sex couples in those states had sued their relevant state agencies to challenge the constitutionality of the state bans on same-sex marriages and/or the refusal of the state to recognize same-sex marriage that occurred lawfully in other states. They were claiming this is going to violate the Equal Protection and Due Process Clause of the 14th Amendment, so violating our rights. Now, the trial courts, those district courts, initially they found in favor of the plaintiffs, though the defendants appealed the cases, and the U.S. Court of Appeals for the Sixth Circuit reversed that lower court ruling and said it was not violating their 14th Amendment rights. So it was only when the Sixth Circuit Court upheld the bans in Ohio, Michigan, Kentucky, and Tennessee that the Supreme Court took on the case. And this is what brings us to Obergefell. Obergefell v. Hodges. Richard Hodges was the director of the Ohio Department of Health, and Mr. Obergefell was the plaintiff. He and his partner, Mr. Arthur, were from Ohio, where same-sex marriage was not recognized. So they traveled to Maryland in July 13 to get married. Maryland had just legalized same-sex marriage that year before in a ballot referendum. Now, Mr. Arthur ended up dying a few months later after getting married, quite tragically from ALS. So my question to you, was this case moot because Mr. Arthur had died? No. The case was not moot because Mr. Obergefell wanted to be listed on Mr. Arthur's death certificate as the surviving spouse. There were material benefits to being listed as the surviving spouse. Being able to cancel credit cards, change deeds on the home, health insurance, taxes, inheritance, you name it. Now, when the case was going before the court, some of the questions the justices were asking were, why now? And why are we the ones to decide this matter? The case really turned, though, on what about the kids, the children of these same-sex couples? So the legal questions that were really prompting this case were, does the 14th Amendment require a state to license a marriage between two people of the same sex? And secondly, does the 14th Amendment require a state to recognize a marriage between two people of the same sex that was legally licensed and performed in another state? Now, the opinion of the court, this was a 5-4 ruling where the majority opinion ruled that the fundamental right to marry is guaranteed to same-sex couple, delivered by Justice Anthony Kennedy, you see here, and Justice Ginsburg, Justice Breyer, Sotomayor, and Kagan joined in that majority opinion. Those were, in 2015, the 9 justices on the court. Now, the ruling of this court, they really relied on the 14th Amendment, and there were primarily 4 distinct reasons why they said the fundamental right to marry applies to same-sex couples. I would be here all day if I went through each of the very long legal arguments for those reasons, but primarily one of the strongest ones was the right to personal choices regarding marriage is inherent in the concept of individual autonomy. So the liberties that are in the Due Process Clause extend to certain personal choices that define personal identity and beliefs. Right? They were citing cases like Griswold v. Connecticut. Be sure to look that up if you've never heard of it. These intimate choices about intimate relationships are protected by the Constitution. And it's really important to remember while we're thinking about all of this, the court is interpreting the Constitution to identify these fundamental rights. It is not establishing or creating any new rights. And certainly there was a lot of precedent are previous rulings that was supporting this idea. Loving versus Virginia, a very landmark case from 1967 about interracial marriage, where the Supreme Court ruled that Virginia was violating an inherent right to marry when they prohibited couples from doing so simply because of race. And really one of the second distinct reasons the court was citing is that same-sex couples have children and families, and they deserve the same legal protection that opposite-sex couples receive. And in the dissent, you'll hear a lot of language that this is not something that should be decided by the court, that they were engaging in what is called judicial policymaking. This should have been left up to the states to hold instead. But a lot of people will tell you, you can't wait for people to decide on a fundamental right. You cannot wait for a ballot referendum to secure that right. And certainly the questions about the First Amendment, this ruling was protecting the rights of religious organizations to adhere to their principles, but it was, saying that it does not allow states to ban the right for same-sex couples to get married. And for many of you, if you decide to stay on and take some more political science courses at UMBC, certainly Professor Davis will talk about this often. He'll ask, what about framers' intent? So what did the framers of the Constitution, who wrote all of this, what was their hope when they were writing? Especially of liberty, they made it intentionally vague. Right? This idea that you don't always see injustice in your time or in its time when they were writing. So the dissent was led by Chief Justice Roberts, saying that this might be good or fair policy, but this really should be decided by state legislatures, similar to what Maryland did, a ballot referendum. You can't have this judicial policy making. And Justice Scalia and Justice Thomas joined in that dissent, kind of echoing similar things in their own dissents as well. Justice Scalia said that they were exercising the legislative rather than judicial power. Justice Thomas said they were taking power away from the legislator and putting it in the hands of the judiciary. So very powerful language there. And Justice Samuel Alito dissented, and he also wrote that the Constitution does not address the right of same-sex couples to marry, and therefore it should be reserved to the states. So another question of federalism, again here in the courts. And finally, I wanted to spend a few minutes on this very famous paragraph delivered by Justice Anthony Kennedy, who wrote the majority opinion for this court ruling. Typically, for Supreme Court rulings, at the end you'll always find "it is so ordered." So very powerful language there. No union is more profound than marriage, right? Kind of emphasizing this idea that marriage is a keystone of our social order. So Poly 100, when you are thinking about courts, their rulings, kind of the political climate, do you agree with the dissent or with the majority? Do you think this is judicial policy making? Should this have been done by every state deciding on their own? Or is there such an urgent need to have the courts decide to make sure that everybody's fundamental right was protected and that it was ensured by the highest court in the land? All things to consider about, certainly not negating the fact that this was a huge win for so many people, LGBT community and beyond. So definitely take time to think about judicial activism. Is it right? Is it wrong? Is there a gray area? And how that might relate. And for anybody who is pre-law or who is now intrigued by the Supreme Court, there are certainly lots of great courses at UMBC that are offered around civil liberties, migration and refugee law, constitutional law. Try it out. You might find that you really are interested in this. And there's certainly a lot of cases coming up soon that will be incredibly important to expanding fundamental rights as well, if that's of interest to you. That's all for now. Enjoy the next few weeks. I hope you get through midterms. Be sure to take time for self-care. That is highly important. And be good, Poly 100.